All right, Madam Clerk, are we ready?
Yes, Your Honor.
All right. Appreciate your patience. We're starting a little later than I indicated. We'll be back on the record. These are cases CR 22-2755 and CR 22-2838, State versus Chad Daybell and State versus Lori Vallow. The court took a recess after considering the closing arguments today, and I'm prepared to make a ruling on these motions. In this case, the defendants have each filed motions to disqualify the prosecuting attorney. The court has considered the pleadings, the evidence submitted in the hearing on January 6th, and the arguments that were submitted today. As a preliminary question, the court has to determine what is the appropriate standard of review for granting or denying these motions. Pardon me. As has been pointed out by both the experts and in argument, there really are no Idaho cases directly on point to identify what is the precise standard for this motion to disqualify a prosecutor pre-trial. And there's no Idaho precedent the court's aware of where this remedy has been ordered by a trial court in a pending case. Neither defendant provided any citation for an appropriate standard of review, but made argument in support of their belief of what the standard should be. The state has referred the court to a standard in the Weaver versus Millard case, which was set forth in the state's brief. That case is a civil case, and while it's instructive to the court, I do share a concern that was raised by Mr. Means in his rebuttal argument that the civil standard may not be appropriate for a criminal case, and that would be because of the heightened duties that a prosecutor is charged with and the additional constitutional protections that are afforded to criminal defendants versus a civil standard. And so in the court's opinion that the Weaver versus Millard may not be the correct standard and will not be used for determining these motions at this hearing. There is some Idaho case law out there that for good cause, a trial court can in its discretion appoint a substitute attorney for an indigent defendant, for example, and that would be State versus Lippert, 145 Idaho 586. However, that is for the constitutionally guaranteed right of representation of an indigent defendant and does not necessarily apply to a trial court having the ability to order a substitute attorney to represent the state. In looking at other jurisdictions then, the court has located a precedent out of New York that is persuasive and will be adopted in this case, as I think this is a novel issue in terms of precedent. The case I'm referring to is called State versus Paperno, a 1981 case out of New York found at 54 New York 2nd 294. And that case deals directly with the issue of a defendant's pretrial motion to disqualify a prosecutor. The standard as stated in that case is as follows. It indicates first, the burden is on, well, let me read that directly from the case. The standard they use is that on a pretrial motion to disqualify the prosecutor, it is incumbent upon the defendant to make an adequate showing that the pretrial activity of the prosecutor will render his participation in the trial unfair. A mere assertion by the defendant that he intends to question some aspect of the prosecutor's conduct is insufficient. Rather, the defendant must demonstrate that there is a significant possibility that the prosecutor's pretrial activity will be a material issue in the case. So according to that, the burden is on the defendants to make an adequate showing that the pretrial activity of the prosecutor will render his participation in the trial unfair. And second, there must be a showing that there's a significant possibility that the prosecutor's pretrial activity will be a material issue in the case. So in reviewing then the motions with that standard, I look at the motions which mirror each other in their allegations. The allegations are number one, that the prosecutor alleged misconduct violated due process rights of the defendants. Under the Idaho and U.S. Constitution, right to a fair and impartial trial, that the prosecutor engaged in coercive, unduly influential, and intimidating tactics to manipulate a material witness in this case. The second allegation in the motions is the prosecutor in this case violated the Idaho rules of professional conduct, as well as the ABA rules by his actions. The third allegation is the prosecutor's alleged misconduct could be construed under the witness tampering and witness intimidation statutes as criminal acts. Number four, the allegation that the prosecutor's alleged misconduct has made him a material witness in this criminal case. And number five, the prosecutor's alleged misconduct has caused the potential for future civil litigation directed at Fremont and Madison counties, as well as the prosecutor. And then number six, that the prosecutor's alleged misconduct has included concealing evidence in violation of Brady and Rule 16 of the Idaho Rules of Criminal Procedure. The court would note that in terms of the fourth allegation about the prosecutor being made a material witness in the case, there is some Idaho precedent on authority on when that occurs, and that would be the State versus Aguilar case. And that case is at 135 Idaho 894, and that states that the party seeking such testimony, meaning from a prosecutor, must demonstrate that the evidence is vital to his case and that his inability to present the same or similar facts from another source creates a compelling need for the testimony. Also, that a defendant has an obligation to exhaust other available sources of evidence before a court should sustain efforts to call a participating prosecutor as a witness, and that case states that such motions are generally disfavored. In determining then these allegations in the standard I've announced, then I've considered the evidence submitted, including the submitted pleadings and exhibit and the testimony of the three witnesses, including Garrett Smith, the attorney from Arizona, the expert witness opinions and testimony and reports of Dr. James Davidson and Dr. Samuel Newton. I've also considered, of course, the transcript of the audio recording, as well as listened to the recording of the potential witness in this case and her discussion she had with Mr. Wood, which was submitted in the evidence of this hearing. So getting down to these allegations, counsel's alleged that there may have been or was a violation of Idaho Code 18-2604, which is Idaho's witness tampering criminal statute. Of course, to make a showing or to sustain the burden of violation of that would require the highest burden of proof because it's a criminal statute, so that would have to be shown beyond a reasonable doubt. Regarding the allegations of the Idaho Rules of Professional Conduct, of which there have been many allegations made, including rules 3.3, 3.4, 3.7, 4.2, and 8.4 of the Rules of Professional Conduct. The court considers as a fact finder in this proceeding that the standard of review to determine if there's been any violation of the Idaho Rules of Professional Conduct would be clear and convincing evidence, and that would be found under Warner versus Stewart, 129 Idaho 588, and the matter of Daw, 128 Idaho 80. In regards to those alleged violations of the Rules of Professional Conduct, the Idaho State Bar governs the licensing of attorneys in the state and also enforces the Rules of Professional Conduct. There's an office of Bar Counsel that conducts those hearings, which are administrative hearings. The Bar Counsel has the responsibility of investigating, and I'll quote from a rule, all matters involving possible misconduct called to their attention, and that's Idaho Bar Commission Rule 504B2. The state, in its brief, pardon me, I think I misplaced that, cites to the case of Cosman versus Dinius, which is 165 Idaho 375, which states unequivocally that the district court appropriately recognized that whether to issue sanctions for an ethical violation is a decision for the Idaho State Bar. So in other words, there's a separate governing agency that would make a determination as to whether or not any sanction should be imposed for violation of the Idaho Rules of Professional Conduct. Now, I understand that as the sitting and presiding court in this case, if I were convinced that an acting prosecutor was engaged in conduct that would result in a fair trial, then I would have an inherent ability to grant this motion, even though, as I have mentioned, I don't see any prior precedent, or I haven't ever heard of that happening. The Idaho Constitution under Article 5, Section 2 does grant the court with the inherent right to administer justice in a case. But again, the standard I'm looking at for the motion would be the standard out of the State versus Paperno, New York case, which is that the question of, one, did the pretrial activity of Mr. Wood in this case render his participation in the trial unfair? And two, was there a significant possibility that this pretrial activity will be a material issue in the case? In this case, then, we're dealing with the comments that were made to a potential material witness, who is the sister of the defendant, Lori Vallow. And as Mr. Evans pointed out during cross-examination, this witness may or may not ever be called to testify at a trial. So that's something I have to consider. The prosecutor, based on these allegations, could of course choose to recuse himself, but there's been no indication that he is doing that. Mr. Woods could, if the allegations were true, be charged under that statute of Idaho Code 182604. There's no evidence or indication that that has happened. There could be a sanction issued by the Idaho State Bar, and their sanctions may include a private reprimand, a public reprimand, a suspension of license, or disbarment. Those are possibilities out there. There is no evidence before the court that the bar has taken any such action. So without knowing whether or not this potential witness will ever be called to testify at a trial, the court cannot find at this time that the interaction between Mr. Wood and the witness would render Mr. Wood's continued participation in this case unfair, and cannot determine that the prosecutor's pretrial activity will be a material issue in this case. For those reasons, then, the motions to disqualify Mr. Wood are denied. Now, if Ms. Shiftlet in the future is called to testify at trial in this case, the court would require a pretrial hearing based on the evidence I heard at this hearing, which has been referred to as a taint hearing, and that was done in the case of State versus Severson, 147 Idaho 694. It's discussed in Head Note 46. So I would require that type of hearing before her testimony based on the evidence been presented by the defendants in this case. The court at this time has no other information of any other such conversations that may have occurred with other potential witnesses. If they did occur, then there may be a possibility of a future request for additional taint hearings for those witnesses as well. But that's not an issue before the court, as the only information submitted was the transcript and recording of the conversation with Ms. Shiftlet. So finally, there were some concerning things in the recording in regards to the derogatory comments made by Mr. Wood about Mr. Means. I'm not going to issue an order to apologize or anything to that effect, but it's certainly my practice to always encourage a civility amongst counsel in my cases, and I'll just leave it up to Mr. Wood to determine whether or not he thinks that is an appropriate thing to do in order for continued civility and professionalism going forward in this case. Finally, of course, if the Idaho State Bar were to take any action, this court would be advised of that by the State Bar Association, and this issue may be subject to being reopened for further findings and conclusions if I received any such information. But any decision regarding a sanction for any violation of the ethical rules, if they did occur, is left to the sound determination and discretion of the Idaho State Bar. So that will be the court's ruling on these motions. Mr. Evans, I would ask that you prepare an order indicating that the motions are denied, and also include in the order the indication that the court would require a pretrial hearing to have an in-camera interview of Ms. Shiftlet before trial, or well, don't necessarily say it would be an in-camera interview, just say that a hearing, pretrial hearing would be required if she is in fact to testify at trial.
Very good, Your Honor. Thank you.
All right. Mr. Pryor, do you have any questions on the court's ruling?
No, Judge.
Thank you. Mr. Means, any questions on my ruling today?
No, Your Honor. Thank you for your efforts.
Thank you. And Mr. Evans, does the state have any questions on my ruling?
No, Your Honor. Thank you.
All right. Counsel, we do have some other hearings we need to get scheduled, including, I guess, hearing on a motion to compel, change venue, and motions to dismiss. My preference, given the time, and I'd like to just arrange a conference call with counsel to look at calendaring and get these matters set. So I'll be available in the coming week. I'll reach out to counsel and let's look at our calendars and see when we want to get these additional motions scheduled. All right. Anything else we need to bring up on the case this afternoon then?
No, Your Honor. Thank you.
No, Your Honor.
All right. Thanks, everyone. And thank you to the Idaho Supreme Court for their support, as well as Fremont County. We'll be in recess.